All rise. The Court of Appeals Division 1 is now in session.
Be seated. Good morning. Now is the time set for oral argument in cause number 1 CACV 13-0242, Yamaha versus ADOT et al. For your information, these proceedings are being both audio and video recorded. So barring any unforeseen problems, you can critique your performance here today on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. And appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up too much of your time. However, ultimately, your reserving time for rebuttal will be up to you. We have reviewed the briefs, we have conferenced the case, so we are well aware of the facts and issues attendant to this argument, and you might want to keep that in mind when you figure out how to use your time and address the court this morning. Counsel, when you come to the podium, I would ask that you each state your name and who you represent. And with that, counsel, you may begin.
Good morning, Your Honors. My name is Maurice Sanchez. I represent plaintiff and appellant Yamaha Motors Corporation, USA. With me is co-counsel Michael Liberti. This matter is about a statute being misinterpreted to provide a monopolist veto over the appointment of a new dealer. This court reviews such matters de novo and is not required to give deference to the interpretation to the statute given by the administrative law judge. We would and have obviously asserted that the administrative law judge misinterpreted that statute and essentially required Yamaha to show that it would not cause any harm to the existing dealers if the new dealer were to be put into business. Yamaha, in fact, did prove that and did show that there was ample opportunity for both the new dealer and for the existing dealers to survive and thrive in this market. Yamaha showed that it's missing 873 sales annually.
Can I interrupt you, Mr. Sanchez?
Yes.
Because one of the issues that I have with your position is it seems you're asking us to reweigh the evidence, which you know we don't do in the context of an administrative appeal. And so it seems to me the proper focus is on what the franchisees proved or failed to prove. The ALJ obviously found that this was the most, I think your major argument is the economic impact factor, and you believe she misapplied the law and misinterpreted the statute. Am I accurate?
That is correct.
So it seems to me the question is what the franchisees offered that would allow her to say that the economic impact on existing franchisees dictated against the new dealership.
Yes, thank you, and that was my very next point. Yamaha's evidence was the only substantial evidence on this issue. Mr. Vivret, its expert, did a thorough analysis, and it's based on the analysis that's recognized in the industry for these matters. The dealer, on the other hand, the appellee in this case, Ride Now, who is the owner of YSA, essentially merely testified that it believed, it thought there was going to be some negative impact. It didn't attempt to quantify that impact in any way. It didn't attempt to show that it would be put out of business. It didn't say if the new dealer makes this many sales, that will mean that we will make this many fewer sales, and if we make this many fewer sales, then we will either be substantially impacted or go out of business. It didn't quantify any of that.
But aren't there tremendous variables that come into play in trying to specifically state that a new dealership that's able to fix its own pricing structure and has any number of different incentives and promotionals? How do you fix a number around an unknown?
Well, you do it the way Yamaha did it in this case. You determine a standard, such as Yamaha used the national standard, and you determine whether this market is meeting that standard. And if it isn't, as Yamaha showed, it prior the Phoenix market did exceed the national standard and average, and now it is well below.
But that was also, given the times that we're involved in here, we're talking about pre-recession as opposed to pretty much coming out of the recession, correct?
Understood, and the economy affects all dealers equally.
But some of the dealers gave huge financial, excuse me, and I want to be real clear on this, non-Yamaha dealers, the competitors for the motorsports, however they're saying it or pronouncing it now, some of those manufacturers gave huge incentives, 50% off the price of a year-old motorcycle.
Sure.
So how do you fault the local Yamaha shops and assert that they're not basically getting it done if they're not able to do the same thing in that same market?
What we were able to show is that, first of all, those incentives are not only in Phoenix, but they are in other markets as well, number one. Number two, those are temporary effects. The incentives don't last generally for more than 60 to 90 days. So and what the evidence showed was that the impact, while for that period of time may be great, overall, we're talking about a 5-year time window, the impact is not that great. It shouldn't be an 873 unit difference.
Well, but the numbers also indicated that the local dealerships rebounded once those huge incentives came off, correct?
They did, but not to the extent where they should have. As I said, Phoenix was once for Yamaha well above national average, and had fallen to well below and had stayed there with no signs of rebounding. That's really the issue. Yamaha tried to work with these dealers for 4 to 5 years before it even decided to go back into the North Scottsdale market, where it had been before, by the way. Ride Now had a dealership there and decided to move it to the other side of town to Surprise.
So I can be clear on this. The dealerships we're talking about had been in business for, it's either 12 or 15 years, I think, correct?
Yes.
And these are the Coulter-owned dealerships?
Yes. Coulter and Tack, yes.
There you go. And so for 12 or 15 years, they're setting those numbers that are competing above the national average. And then we go into the recession, and coming out of the recession, they're not able to compete with those numbers anymore?
They didn't own 5 out of the 8 dealerships in town during those years. They owned a couple. They acquired more over time. And we would contend that as they essentially created a duopoly with themselves and with the Apache group, both groups owning all 8 dealerships, that is when the numbers started going, in addition to the economy. See, the economy, in a sense, is a little bit of a red herring, because yes, it did affect it, but it affects everyone. So Kawasaki,
Clarify
Suzuki.
that, because that's the second. You said, and I wrote it down because I wanted to follow up, you said, quote, the economy affects all dealerships equally. What do
Yes.
you mean by that? What dealerships?
What I mean is, all dealerships in any market are affected by the economy.
Is what you were
Yes,
intending.
in this market are affected by the economy in that market.
Okay, hang on. Geographical or economic market?
Well, we measure things geographically.
Okay, so you're saying that in this geographical market,
Yes.
everything affects everyone equally?
All dealers of all line makes are affected equally.
Thank you.
Is that supported by any evidence in the record? I thought
Absolutely.
I thought your expert, and I may be wrong on this, but I thought the expert said he never really studied the Phoenix market.
No, he had studied the Phoenix market for the purposes of this case. He didn't live here. I think the criticism by YSA was he wasn't a Phoenix-based expert.
Okay.
And that is true. He is based in California, but an expert studies markets the same way nationwide, as do all experts
Well,
that
he
do
had,
this
he
kind
had
of
clearly
analysis.
studied the Phoenix market in terms of the lost sales opportunities, but I thought there was some indication that he had not studied the Phoenix economy and the effect of the economy specifically on the Phoenix market as opposed to other markets. Was that accurate?
That is true, but basically what most experts in this area and what he testified, you don't have to, because the sales are known. So the effect of the economy, of demographics, of all these other factors translate into the sales. The sales are what matters. So everybody knows the economy was bad at in 07, 08, and so the numbers went down for everyone. That's why what Yamaha is expressing as a national market average or national sales average is a percentage. It expects to get a certain percentage in nationwide and in each market if it can do so. And when Yamaha was well above that percentage in Phoenix and then fell to well below, the percentage is what it wants, not the raw sales numbers.
Not all markets, not all geographic markets are affected the same way in a recession.
True.
For instance, San Francisco wouldn't have been affected the same way Las Vegas or Phoenix had been hit by the economy.
That's true, but because we're taking a national average, all of those idiosyncrasies of each market basically balance out. You've got large, you've got small, you've got coastal, you've got desert, mountain, etc. That's why the national average is a nice average, because all of those things do balance out. And that's basically what the expert testified to. Contrast that with YSA. I asked each and every YSA witness, did you do a study? Whether it be an internal study, an outside expert, it didn't matter. And the answer uniformly from each of them was no.
But doesn't that go to the weight to be given to the evidence? And the ALJ balanced that, and we know we don't reweigh the evidence to see whether we would give it more weight or less weight. I think when you're arguing your evidence was better than theirs, in the context of our review, that's probably not your best argument. I do have some interest, though, in your argument about whether the ALJ applied the correct legal standard to the E4 factor. In fact, that's the issue that interests me the most. Okay. What is your best argument as to why, as a matter of law, she misapplied that factor?
Because essentially, and this ties into the other argument you've also stated, we presented a substantial study provided by an expert. The other side basically admitted they did no study. It was there. In fact, the judge is quoted in one of our in our reply brief. I'm letting them testify as to their feelings as to what's going to happen if this dealer is appointed. Well, the feelings really don't tell us much. That is not substantial evidence. And so I would say that Yamaha is the only party in this case who presented substantial evidence. The other side did not. They presented a lot of testimony. They presented a lot of, we've been in business for many years and we've had to do this and we've had to do that. But nobody sat down and studied, how is this really going to affect us? How can we predict what the effect of this new dealer is going to be? That's what an expert would do. If they chose to want to do that in-house, they could have certainly done so. They chose not to. No analysis, no study was done. They testified as to what they thought and what their feelings were going to be. I would submit to you that is not substantial evidence sufficient to support this decision. The ALJ then, on top of that, makes the amazing statement that general business sense is that less competition is better. I would submit to you that's just de facto wrong. Less competition is maybe better for the existing dealers. It's never better for the public.
It isn't, I mean, I agree with you that that statement standing alone out of context raises some antenna, by me at least. But read in context, and especially given the following sentences and paragraphs of her ruling, isn't it clear that she was talking about less competition is better for the existing franchisees?
Well, no. If you permit me, Your Honor, what that sentence follows is a statement that Ride Now and Apache did not prove a negative economic impact on their business, but general business sense indicates that less competition is better. So it follows upon a finding that this judge made that YSA and Apache, which did not file an objection, did not prove that there would be a negative economic impact on their business. Frankly, the analysis should have stopped right there. Once Yamaha had some evidence to show that it wouldn't affect them, and they had no proof of negative economic impact, it should have been over. She then makes this general statement about less competition is better, and I believe goes off in the wrong direction. Basically, the ALJ's decision is founded on three unstable grounds. The first I've already mentioned, her statement that the general business sense is that less competition is better. Certainly not better for the public. Further,
but she finds specifically that in fact it is. Isn't she pretty specific about her concern about how this is going to impact on the public, and makes a series of statements in her findings of fact regarding the fact that the public will suffer if the petition is granted.
That's not exactly what she said, Your Honor, with all
Okay.
due respect. What she said is, if this dealer goes in and if it takes sales from YSA and Ride Now, and if those are dealerships are forced to lay people off, and if they're forced to close, those are all ifs, ifs, ifs. Again, there's no proof to support those ifs. There's only, we think it's going to happen. There's no study, there's no analysis, there's no substantial evidence to that effect. So, yes, she does say if all of those things happen, then the public might be harmed. But as I said, Yamaha presented the 873 lost sales, gives ample opportunity and potential for not only the new dealer, but for the existing dealers to survive and thrive.
I read her decision as being in the alternative, and as far as damage to the public. On page 15, she says, if the dealers do close or experience a significant loss of sales, your express purpose of eliminating the monopoly of the two dealers and offering a third alternative would be defeated. If they do not change their business practices, your desired purpose of improving the dealer's business practices due to intra-brand competition would also be defeated.
Right. And that is where she basically makes an assumption that dealers who are facing stiff competition are not going to change their business practices to meet that competition. I think it could be safely assumed that's not what's going to happen. People who are in business to compete with each other, generally, if somebody does something, we've got to meet that competition and do something to respond to it.
Well, unless the new dealership is getting incentives and other support because it's an exclusive dealership from the manufacturer, which could drive in essence, drive the existing franchisees who are selling other product lines out of business.
There was no evidence to that effect that Yamaha favors one dealer group over another. In fact, remember, this is one dealer that's going into business versus 5 from Ride Now and 3 from Apache. I think it's difficult to say that one dealer is somehow going to trump all 8 of them.
It was going to be an exclusive product line, right?
It was. That was the proposal, sure. So she misunderstood the lost sales analysis, and she refused to accept that there was an opportunity for both. She basically makes the statement as well that if GoAZ made a sale, then Ride Now and Apache would lose a sale. That's not what the evidence showed. What the evidence showed is that those sales are going to other competitors, and that there is ample opportunity if Yamaha attained its market share in this market for all to survive. And finally, she chose to accept the conjecture of Ride Now and Apache of the sort of parade of horribles that would happen. If this one dealer challenged their duopoly in this market and went into business and shook things up a little bit, actually giving them competition where YSA's manager testified, we don't compete on price. We compete on everything except price. Well, to many consumers, that's what's important. You want to see competition on price.
So there's no question about it that the new dealership would be in a position, even with initial capitalization costs and new overhead costs and everything else, they would immediately be in a position where they could, and I use this not in the pejorative, but undercut, they could reduce the cost of their sales of Yamaha products below that what these 15-year existing dealerships were able to.
Well, what the judge found is that Ride Now has this business strategy where they add on products. This is her products and services. This is her finding, I believe, 106 and 107, where she basically said they add on insurance, tire insurance, service contracts, accessories. They add all sorts of things. And if you want to buy from them, you have to buy a unit with those things on them because they don't compete against each other on those things. So the judge found, yes, that does add to the price of the vehicle. What they don't like is this outsider coming in, shaking things up, making them be better competitors. And frankly, that's what our system is built on. Our system is built on competition.
And why have this statute?
Because you don't want to go too far. You don't want Yamaha to appoint
too much
100
competition.
dealers, but you don't want Yamaha not to be able to replace a dealer that it had in that market before.
That statute's basically aimed at protecting, at finding good costs to protect franchisees from overreaching by manufacturers and franchisors.
I would phrase
right?
it a little differently. I don't think it's a protection statute. I think it's a balancing. It asks a third party, an ALJ, to do a balancing test. Is this going to put somebody out of business, or does this market need more competition? And I would submit to you that essentially the proof that this judge required was that there be no harm. And because of the substantial evidence by Yamaha, lack of substantial evidence by the other side, it wasn't proven.
Let me just make sure I understand something. Where did she say you have to prove no harm?
It's not stated in those words, but basically what she says is, if this happens, if that happens, if that happens, then they may go out of business. Well, there's a lot of ifs before you get there.
Okay.
I have about a minute left. I'd like to reserve it if that's okay.
Thank you, counsel.
Thank you.
Jack Snyder, Jennings, Haugen, Cunningham, appearing for Appley YSA Motorsports LLC. We actually call ourselves Ride Now Phoenix. I took the first half of my argument and put it away because it's pretty obvious that explaining to you about Arizona's franchise regulation and dealer protection statutes is obviously completely unnecessary, and I appreciate that. Yamaha is very frustrated by the outcome in this case, and one of the reasons is they brought in an expert, and I use that term loosely, and they brought in this gentleman who only testifies for Yamaha, who's been paid millions by Yamaha, who uses statistics compiled by somebody else, the Motorcycle Industry Council, and puts together these wonderful charts that say that if you compare how much the market share of Yamaha is in the entire country, and then you compare it to the Phoenix market, you find that for that time period, the Phoenix market was lower for Yamaha. Therefore, if we sell 1,000 units in Phoenix, and it's, 36% nationally, it's 28 here, there's going to be hundreds of units that they call missing units or lost units. The whole construct is a big fiction. Nobody cares how many units Yamaha doesn't have. The question is, and our judge understood that, is why? You have to ask why. I mean, anybody can compare a bunch of numbers. And that's what we spent our time doing. That's what my client focused on. And they say, well, yeah, you didn't bring in an expert. The last thing we wanted to do is have this case be a question of two number crunchers who would talk about all these numbers in some abstract concept and not talk about the core issue, which was why. What we did instead is we brought in the people that work for our organization who have decades of experience selling exactly the product we're talking about, including Yamaha product, and in fact one of whom, the most prominent, which truly favors the Yamaha product over other manufacturers, and has done this for decades in this market, ups, downs, good, bads, knows what drives, knows what sells, because they've done it. They didn't read a study. They didn't go borrow numbers from the Motorcycle Industry Council. More importantly, and really telling in this case, the testimony of Mr. Richards. Now, he's the guy that runs Apache Motorcycles, not a party, not my client. So the only person testifying who wasn't either a Yamaha person or affiliated in some capacity with either the Ride Now group or with YSA Motorsports. And he came in and he corroborated all of that. He also has decades of experience selling motorcycles, nose-to-nose competition with our client trying to sell motorcycles. And for example, we talked about, Mr. Sanchez mentioned at the end, oh, well, Ride Now has a way of doing things and they add stuff to the price and they're not price competitive. That's not what the testimony was. What the testimony was is that in the modern internet age, any monkey can figure out what price a dealer is going to charge. And since the manufacturer has certain limits, as there are limits for just how much you can sell, unless you can take a loss, there's only so low you can go. So anybody can go on the internet and figure out where to get the best price. And in fact, that's why you have to compete by saying, I have a beautiful store, I've invested millions of dollars. I have staff who are really well trained. They're personable. They're not just somebody I found. I mean, I really want them to make an impression. I have really great service. People like to come to my store. I do rides. I have clubs. People affiliate with my store. This is how competition takes place in the modern age in the motorsports industry.
Counsel, I have a question for you. Do any of the studies indicate, we keep talking about these 800 lost sales. Do any of the statistics that came to light in this matter address, is a Suzuki rider, or is a Suzuki rider willing to buy a Yamaha unless there's a cheap Honda out there?
They don't address that. What they do is look at and say how much is sold in a market of a certain unit.
So the
in a certain
assumption
time
is
period.
that a person who is willing to go to Suzuki would also be willing to go to Yamaha if they could get a better price. Is that how we get to 800 units?
No.
And here's the reason for the question.
Yeah.
Because the ALJ made a comment about the fact that if your client, if the appellant's client obtains a sale, it's at the expense of your client.
Well, a couple things.
So
I
is
think
it
in
an
that.
industry-driven sales mechanism in just that product, or do people literally buy motorcycles across the board based on the cheapest unit they can locate?
The studies don't answer that question that were used at this hearing. I think that we all understand that price is a factor, but not the only factor. There are undeniably people who are brand loyal. There are undeniably people who are price motivated. What we found and what we testified to is that if one of the manufacturers with whom Yamaha competes comes into the market and says, I can sell ATVs in Phoenix like crazy. People are not as big on them in Montana, but they sell good here. And says, I have all kinds of last year's units because I built so many and then the market tanked. So they assemble them throughout the country. They bring them to this market and they dump them here at monstrous discounts in order to get rid of them. That means that more, and I'm just going to use a name, more Kawasaki's sell. And if more Kawasaki sell, then the percentage of sales in the market for Yamaha drops. It's just a statistical fact. And it had an effect. But our people didn't say, oh, there's this one reason. They didn't say it's just incentives. They didn't say it's just because of the dumping. And all those things Mr. Sanchez said are true. You know, those things have a time span and effect. Here's what was amazing as you sat and listened, is Yamaha brought in this big, long list of statistics for all these years. And the guys from Apache and from Ride Now could sit down with those statistics, something Vivrette couldn't remotely do, and they could tell you for every blip on there what it was. They would be rattling off the names of certain models, and Yamaha brought in this really cool 250 at this time, and it was hotness, so see how they jumped. And then over here, you know, Polaris started improvising with the use of this type of a product. Those guys could explain everything in that. It's not at all surprising that the judge found that testimony incredibly persuasive and a set of numbers thrown up that couldn't be explained by somebody who'd never sold a motorcycle in this market, didn't come here and analyze the product mixes historically, and in short, really didn't do anything other than prepare a flow chart. That's
Can I
where the
jump
case.
in here?
Sure.
Because, as I said to Mr. Sanchez, given the standard of our review, we don't reweigh the evidence. If the evidence was competent, then it's for the ALJ to weigh, in my view. The issue that most interests me and that I think you're most vulnerable on is their argument that she misinterpreted the statute in applying the E4 factor, economic impact, on existing franchisees. And there are a couple of parts of her decision on pages 13 and 14 that could be read to support their argument.
Yes.
She says that your clients didn't prove they would be negatively impacted by the appointment of a new dealer. General business sense, however, suggests that less competition is better. That raises some red flags. And then earlier in that same paragraph is the statement that Judge Jones alluded to, where she says, seemingly categorically, if Go Arizona makes a sale, then Apache and YSA lost a sale. Some of those statements could be read to support their argument that she misinterpreted this factor. What's your argument about that?
Okay. I think that if you have the whole record, if you were there for 5 days of witnesses and evidence, you can see that what she is saying when she says less competition is better is she's not making a generic statement about, democracy and communism and all the other good stuff that seems to be implicated. Instead, what she's really saying is another dealer point, that kind of competition is not a good thing here.
Do you read it as meaning it's not, less competition is better for the existing franchisees? Is that how we
I
should
think less
interpret that?
competition is better for existing franchisees, for the public as well, because if you have 8 starving dealers, adding a 9th, and you'll see she talks about this. Yamaha doesn't care. They don't mind, because in the end, the units sell because the units sell. If 3 people go out of business, they still sell the same number of units. What she's balancing there is she's saying, look, it's been a tough time. It's been a hard market to stay around in. These folks did thousands of percentages more in sale volume in previous years. They're enough. There's enough representation, enough capacity. So adding competition in the form of another dealer will not benefit the public and will hurt the franchisees. It's common sense, and I think she used a lot of that. Now, she had a habit of saying, on the other hand, she would say, here are all the things I think I heard. I think I heard them say all of this. And it does create a decision that in many ways, if you read just parts of it, it makes it look like she's doing something wrong. But when you look at the balance, I really think when she's saying competition, she's talking about adding another dealer point, not competition generally. And this whole...
It's not a general economic principle she's espousing.
Right. She's saying it in the context of what she heard and the evidence she heard. And I think it's really important to remember this whole monopoly thing. I don't know, but I thought mono meant one. And for the first time I heard Mr. Sanchez blend in a 2. But if you have 2 competitors who are going at it neck and neck, and Mr. Richards testified, well, Ride Now tries to do this whole branding thing. We're the Walmart of the Ride Now power sports business. That's what he said. You have competition at price levels. You have competition at service levels. You had a lot going on there. And I think this notion that these dealers control the market is a joke. I mean, these locations are there because Yamaha permitted them to be there. Make no mistake about it. The protection statutes exist because these dealer agreements and the things that the dealers can do to the manufacturers can do to the dealers are profound. And this notion that they've somehow been boxed out, no cause of their own, is really disingenuous. I think what she found is the dealers we have are trying very hard. Another dealer just recently failed. There's enough competition, and more competition is not necessarily a good thing at this time. She uses the words "at this time" at one point in the ruling as well. I don't think she's making general statements. I think she's trying to identify a particular problem and decide on a particular day under a particular proof, is adding another dealer point going to be good for the public? Is it going to be harmful to the franchisees? And that factor, it's 1 of 5. I think that's very telling. If she had come in and said, I can't decide on this economic harm thing, I think it's a complete toss-up. But as to the other 4, I clearly find there's not good cause.
The problem,
She'd be right.
The problem with that, I think, is that if she was wrong on one factor, and we don't know how strongly she weighed it, it might require a remand to have her rebalance all the 5 factors. Because she didn't say, she basically, right, I think you're correct in your briefs that it's all 5 factors, and 4 of them point to affirming, but if she's wrong as a matter of law on one, that could affect, okay, you were wrong on this in the way you interpreted the statute, and therefore we have to remand it. But it seems to me that at least as I read her decision on the E4 factor, is that what she's basically saying is no one can definitively show anything as far as whether it definitively, I think is a key word, as far as economic impact, E4 factor. But based on everything I've heard, it's more likely that an added competitor will reduce sales and negatively impact the existing dealers.
Intellectually, I agree with you. If we all were firmly convinced that she just misapplied a factor, we couldn't ignore it because of the others. I'm not sure that the court couldn't find that because of the number of factors that nonetheless her decision wasn't capricious, but let's assume that she can't. when you look at the factor, it doesn't say the specifically quantifiable economic loss that an existing franchisee will suffer as a result of it. It says the economic impact on existing franchisees of the same line make. And it's just a circumstance that she should consider. Absolutely she considered it. She wrote about it. But I think she could even find in favor of Yamaha. And if she felt the other four militated against it, then she could do that.
If she
But
had done, if she had done that,
Yeah.
and we said, well, okay, well, then that would be a different issue. But here she's finding on all 5 factors.
And she's clearly considering them. In her opinion, she lists them. She's not ducking. And she adds others because it says, it's not just these 5. And I think the suggestion by Yamaha that you somehow need to listen to their really compelling case, I think, as you've pointed out, really misses the mark. We had that trial, and she heard all of that. There was competent evidence from people who do this for a living, who actually work here, who actually run dealerships, who know the market, who could answer the specific questions. What happened when you moved a dealership out of Scottsdale to the other people's, business sales? What happened when this happened? How many people did you lose? How much market share did you lose when the economy tanked? These were the specific answers that these folks could provide, not these kind of general. It's just so outrageous to say there wasn't any competent evidence. And, of course, there's a lot of adjectives in the briefing saying, what's wrong with that evidence. But I really think that there's no question there was evidence. Yamaha doesn't care for it, doesn't want the court to follow that. I think I've explained the notion of why we think this whole missing units analysis was unpersuasive to her, that we offered something more specific in response to it. I think it's very important to look at the overall language and purpose of the statute in the context of what's going on here. This protected zone of 10 miles that's set up by the statute, it has meaning. It is unusual or atypical for a manufacturer to come in and seek to stuff in another dealer. Obviously, it's to be nice, it's an affront.
But counsel, there was another dealer.
No, to put in a new dealer within 10 miles of
There
us.
was another dealer.
Yeah.
And they needed to move.
Well, what was actually, we had testimony about that at the hearing. What actually happened is there was another dealer. It was Desert Motorsports. They were in Scottsdale. At the time they were there, we did not own Ride Now Phoenix. We did not own YSA. So you heard testimony from Mr. Coulter, Mr. Marks, Mr. Nash. People knew about that. What happened is that Scottsdale dealership we did own, Ride Now moved to its current location. Ride Now, YSA Motorsports predecessor, moved to the current location, which on Cave Creek bends towards Scottsdale. So they got closer. And we saw a drop-off in our business at Desert Motorsports. They were too close. And we went to Yamaha back in 2002 and said, we want to move Desert out to the Northwest Valley. We see growth out there. We see potential. There's room for a new dealer. We can be far enough away. It's not a problem. Will you give us that permission? Because we get it. And eventually that was granted. In 2006, we took that location out of Scottsdale and we moved it out there. It did dramatically better. By then, we had acquired the YSA Motorsports location. And guess what happened to its sales when we took that store out? They increased. Now they say, well, it's not clear what the reasons are. Well, the people who testified, who were there when it happened, they think they knew, and they pointed out how the traffic counts went up, the volume of customers went up. So, yes, there was one out there, but they could have replaced it within 2 years under the statute and didn't need anybody's permission, just like they can put a new dealership anywhere they want outside the 10-mile zones.
But didn't they also take the position that moving that franchise did not result in underserving the Yamaha buying public in that area?
That when we moved away, it didn't result in an underserving?
Not result in underserving, was my understanding.
I'm getting lost. I think I got two negatives in there.
And maybe. There was no reason to keep them there because moving them would not result in Yamaha buyers not having access to Yamaha service.
Yeah, I don't know. I don't think I heard that.
Okay.
I mean, to be honest with you, I don't think I heard that. It makes sense, but I don't think I heard that. I think that we felt as right now Phoenix, we could certainly reach into Scottsdale and serve that location. We did. Their own stuff shows we get customers from over there.
Was it in connection with that move that there was some statement attributed to Mr. McKim about realizing the market couldn't support?
No, there was a further north dealer who was a single-purpose Yamaha, because there was some discussion at the hearing about having a dedicated
one that
Yamaha
closed.
dealer was important. And that's the one that Apache owned, and they said, we can't survive on this, and there was an acknowledgement, at least by one person at Yamaha, that really this market just probably can't support another dealer. So it was a different one, actually.
Thank you for the clarification.
Yeah. I mean, bottom line is, while I understand Yamaha's frustration, I could talk for a very long time about our frustration under these circumstances. I think the statute serves a very important purpose. I think that the hearing officer was extremely gracious in allowing this extended presentation by Yamaha over 5 days of evidentiary hearings. She was there. She heard it all. Clearly, her ruling reflects a lot of time and effort and work. She didn't, rule in favor of one and mail it in. Sometimes, I wish she had said less. There are certainly things that she said I don't agree with, although I have to admit that even on the things that she said, we didn't do this or we didn't do that, while I don't agree with her, she never said any of those things without having heard another witness from the other side say it. So I think the on the other hand approach of let me tell you all the things I heard here, and then let me tell you how I balance them is exactly what she should have done, notwithstanding my frustration as a litigator, wanting her to only say nice things about my client. And I think that's just another reflection of the balancing she did, and that's all she can do. The statute doesn't say how to balance the 5 factors. It does not say how much to weight them, and it doesn't say what priority. And so I really don't think this court is asked to or should rebalance those for her.
Thank you, counsel.
Thank you.
Yes, very quickly. First of all, it's not a protection statute. There's a protest zone. You can protest it. There's not an absolute protection against somebody else going into business. As far as the less competition is better, let's look at the judge's actual words. She says, general business sense indicates that less competition is better. She's not saying in this case, in this dealer, in this particular situation, less competition is better. She's saying general business sense indicates that less competition is better. I would tell you that phrase is just as important as the other one. She's making a specific statement about how she applied the factors in this case. As far as what Mr. Schexner mentioned, that these were people who were actually in the market and who actually knew, what was going on. There's one question that he asked Mr. Nash and about the Scottsdale store, and Your Honor, Judge Jones, you asked about this. What happened when YSA moved to its current location? And he says, what told you that their business dropped off? Observation. I didn't run the numbers. I didn't attempt to quantify any measure in any way. This was the type of testimony we had. I didn't measure it, but I just know. I had a feeling that it was going down. I had a feeling that this was happening or that was happening. That's the kind of quote-unquote evidence that we heard from the other side as opposed to the substantial evidence that Yamaha presented. Thank you.
Thank you, counsel. With that, counsel, oral argument is concluded. We deeply appreciate the time and attention you spent to these issues and putting up with our questions today. Thank you for that. At this point in time, the matter is under advisement, and we will rule in due course. Thank you.